Welcome to Back Talk Live. I'm Tom Hardigree. This is Lee Brinson. You might notice we're in a different spot. They're doing some renovations to the studio, so we're at Katichi on the veranda. You know what we do? We go to all these governmental meetings and we try to tell you what's going on and hope that you'll call in and tell us what's going on. Tonight, don't call in because we don't have that capability tonight. What we do have is we have our District Attorney Parks White as our guest. That he will be with us the first half of the show, and then Lee and I are just going to try to shoot the breeze and do what we can about the governmental meetings that we've been to. But hang around for Parks White. We will be right back.
Tom, I'm sorry we're having to sit outside, but it's cooler out here than it is inside my house. I'm about to burn up.
No problem.
What I had in mind was to call McGee Heating and Air.
Oh.
Our telephone company is now offering voicemail to email. Whenever someone leaves a voicemail on your landline, it is immediately forwarded to your email account as an audio file. You can then double-click on the file and listen to your message conveniently from your desktop, laptop, or smartphone. You no longer have to wait until you get home to check your voicemail. Call Hart Telephone Company today for more information.
Welcome back. It is Back Talk Live, special edition out here outside at Katichi. We're very grateful to Katichi for allowing us to be here. We're also grateful to have a fantastic guest with us tonight. Parks White is the district attorney for the Northern Circuit of the 10th Judicial Administrative District of the state of Georgia, and there he is right there. Welcome back, Parks.
Thank you very much for having me.
How's it been going for you? You enjoying your new job?
I'm loving it. We hit the ground running back in January, and we've been just taking this thing full bore, working as hard as we can to try to bring down the backlog across the circuit, streamlining the process, working hard to make sure the cases come in from the warrant stage and get indicted faster, we get them arraigned faster, we get them to trial faster, and we resolve these cases rather than letting them languish. But so far, we've managed to bring the backlog down, even while taking on new cases by over 12%. We've added new technology to the office that allows us to be more efficient. We've gone through and done a systematic evaluation of areas which we can spend less money and still have better operating capability in a lot of areas. For example, we've moved from AT&T to Alberton Net in Alberton for our internet service, which is much cheaper, and yet it's a faster transmission rate for internet service.
Wow.
We moved to a different phone line in Hart County that's taken the cost of long distance from $1.60 a minute down to 9 cents a minute. So we're doing everything we can to really try to make sure we tighten our belts and cut costs, but also work as hard as we can to get this backlog behind us while still making sure that we're representing the state in a way that keeps the public safe.
You had said when you were running for office, when you were on the last time, you had said that you would probably try to tack some hides on the wall early to encourage other people to, instead of waiting around hoping the statute of limitations would run out, they would go ahead and plea bargain. Have you noticed any of that yet? We have.
In fact, one of the first cases that came up to the point of trial was a notorious drug dealer here in Hart County, and I'm not going to refer to his name. It was in the paper, but he had 6 prior felony convictions. He had 2 pending drug cases: 1 possession of cocaine with intent to distribute, 1 sale of cocaine. They were both from 2010, and he had not resolved his cases, not entered into any sort of plea, and just been out on bond the entire time. So I filed a recidivist notice against him, which is under the Official Code of Georgia, Section 1710(7)A and C, which would require the court to impose the maximum sentence for him, and then whatever sentence the court imposed in confinement, he would have to serve every day without parole. And the defense attorney I told him initially, you need to plead him now or I'm going to file this notice, I'm not going to waive it. He didn't plead him. So I filed the notice, said no deals, let's go to trial. The day before trial, he filed a motion to suppress, alleging alleging that there were problems with the search warrant, which I didn't believe they were, and the judge ruled in my favor. That night, as we were getting ready for trial at about 10 o'clock, the defense attorney asked me for my best offer in the case. And I finally said, I'll tell you what, I'll plead your client guilty to possession of cocaine with intent to distribute, and if he pleads guilty, I'll recommend a life sentence. And he pled him guilty the next day, rather than go to trial. So that's the kind of a life sentence. Now, for drugs, that means he'll technically be eligible for parole in 7 years. It's not a guarantee, but he'll be eligible for parole. But he will be on parole for the rest of his life. And if he just gotten like a 15-year sentence for drugs, which seems like a long time, he would have been out within like 3 years. So this is a substantial sentence, and it sends a message to the community, a message to drug dealers and to those who deal in crime, that we're coming after you. That in the Northern Circuit, justice is coming.
So this guy, the best deal he could get for his guy was life?
It was life, and he thanked me for it.
Well, at least I guess that was better than death.
Now, you had a case, we were talking about before we came on the air, a case that was settled today, or whatever, I don't know how you say it, concluded today.
Right.
Tell the audience that it's very interesting. I think most people are going to remember the incident, the crime.
Well, the last time I was on the show, someone actually called in about this, and it was a friend of theirs who was killed by a drunk driver last year. And the incident occurred on April 16th, and the case came to trial this week, Monday, in Franklin County. The defendant's name was James Thomas Dixon. Mr. Dixon had at least 5 prior DUI cases and DUI drug cases that were never prosecuted to completion by the former administration. One of them was dismissed 1 month prior to the day of this incident. Mr. Dixon had gotten another DUI drug case 2 months before this incident in February of 2012. And he had a litany of DUIs throughout his history and only one conviction dating back to 1988. All the rest were just arrests. In this case, on the day of the incident, Mr. Dixon was operating a 1992 Buick LeSabre and driving north on Highway 17 while under the influence of methadone, which is a synthetic opioid, alprazolam, which is a benzodiazepine, it's also called Xanax, a tranquilizer, diazepam, which is also called Valium, nordiazepam, which is an active metabolite of diazepam, and alcohol. And he crossed the center line for no apparent reason, and he struck a Chevy Silverado driven by Julie Powell of Reedsville, whose passenger was her husband, Bobby Bland. They were bringing a trailer back from North Carolina where they had delivered a load of onions. The force of that impact, which is primarily on the passenger side, front passenger side of both vehicles, caused the vehicle being driven by Mr. Dixon to raise up into the air and turn. And as it did so, white Chevy Silverado driven by Joey Hart was coming in the right lane of that double lane on 17 South. And Mr. Hart's vehicle struck the bumper of Mr. Dixon's vehicle, and the bumper was shorn off and passed through the passenger compartment of Mr. Joey Hart's vehicle, killing him. It crushed part of his skull. It caused his vehicle to careen off the roadway, and there were tire marks across Mr. Hart's vehicle from Mr. Dixon's vehicle. It careened off the road to the front and went off into a ditch, flipping over, and he was killed instantly. Bobby Bland he was 77 at the time, was seriously injured, and he was transported to the hospital via emergency airlift. He had he had a skull fracture and broken ribs, and he died from internal hemorrhage in the brain. Mr. Dixon survived.
Now, Dixon is
he's the accused. He's the driver.
He's
the person with all the prior DUIs. He was life-flighted from the scene with a broken leg and other injuries to Greenville Memorial Hospital, where he had an hour and a half after the incident occurred a blood alcohol concentration of .083, which means he would have had a blood alcohol concentration of at least 0.1 at the time of the incident, along with this myriad of other drugs. The Georgia State Patrol worked with the South Carolina authorities to obtain a search warrant for his blood, but it took some time to get that search warrant. And this accident occurred at 3 o'clock in the afternoon. Remember, he had all these substances in his system at 3 o'clock in the afternoon. It's at 10 o'clock at night that they actually was served the search warrant on him and get his blood. And even at that time at night, he still had methadone, diazepam, nordiazepam, and alprazolam in his blood. He also had THC metabolites in his urine. So this guy was just a floating human landmine dropped on our roads. And unfortunately, he ended up taking the lives of 2 people and seriously injuring a third. Miss Powell lost her spleen as a result of the accident, and she also had serious injuries.
And what was the defense?
The defense was, it wasn't my fault. All the witnesses, there was an independent witness who saw the whole thing happen from behind Miss Powell's vehicle, that saw Mr. Dixon swerve into the oncoming lane of traffic, striking the vehicles, and his testimony completely was exactly as the reconstruction experts from the Georgia State Patrol, the specialized collision and reconstruction team, came out and put the scene, back together, essentially, through an investigation. And their conclusions were just that he'd crossed the center line and impacted the vehicle, Miss Powell, resulting in the impact of the vehicle driven by Mr. Hart. His defense was, the white vehicle came at me and the trailer was going wild, and I jerked the wheel in order to avoid it. None of which corroborated. Oh, and the best part was when he testified at trial that after the wreck, he was screaming in pain, and he noticed a bottle of Xanax next to him, so he reached over and took one, and then he opened up the glove compartment and put it in the glove compartment. That was his testimony from the stand about how the Xanax got in the system, because he was prescribed methadone and diazepam, but he was not prescribed Xanax.
Well, now, can if you're on a prescription drug that makes you crazy, that can be used. I mean, you're not supposed to drive, right?
And a person can drive under the influence of a prescription drug so long as they're not rendered less safe to drive. But in the case of all these central nervous system depressants, which each one of these is, methadone is a central nervous system depressant, diazepam is, nordiazepam is, alprazolam is, and alcohol is, as we all know. Sure. You combine the things, they have a multiplying effect. It's not just 1 + 1 or 2 + 2 = 4. It's like 2 + 2 = 5 or 7. They get the effects on the central nervous system, memory, coordination, judgment, are compounded. Reaction time, all those things are compounded. And in my opinion, that Mr. Dixon simply blacked out on the road and veered off into the oncoming lane of traffic. Because when he was questioned by the Georgia State Patrol at the scene, who did a great job in the case in reconstructing the scene and investigating, he simply said, "I don't know what happened." When they went to serve the search warrant on him and get his blood, he was eating a popsicle and watching Andy Griffith. Apparently with no regard for what the lives he had taken.
All right, so what was the outcome?
The defense was also that they had a defense expert who testified that Mr. Dixon, because of his history of taking methadone and diazepam, would not have been under the influence of these drugs to the point that he was impaired. We had a rebuttal expert who testified that, in his opinion, he absolutely would have been impaired, would have been a less safe driver, and of course, the .083 is per se over the limit in Georgia for DUI. He was charged with multiple counts of homicide by vehicle, as well as serious injury by vehicle. The jury found him guilty of all 12 counts in the indictment, and the judge sentenced him to 50 years in prison.
How many?
50 years in prison.
When's he eligible for parole?
Parole eligibility in a case like this, I believe he'll be eligible technically in 7, but that's up to the parole board, and we're going to make sure that they know our feelings on at what point they should consider Mr. Dixon for parole.
It's a good time to take a break. We are talking with Parks White. He's the district attorney for our area, and we'll be. We are back. It is Back Talk Live from a special location. It will be called Katichi, and we thank the folks at Katichi for allowing us to broadcast here tonight. Our studio is under repair and or
renovation.
Renovation. And hopefully we'll be back in home soon. But tonight we have with us Parks White. He's of course the district attorney for our circuit, and we're talking about Parks. By the way, thank you for coming back after you got elected.
It's my
Some
pleasure.
people won't do that for some reason, I don't know. But, we're talking about this case, a conviction, 50 years now. How long did it take this jury? Why did this guy go to trial? I mean, did he really think he had a chance to
I didn't
beat it?
offer him anything.
Okay. So how long did it take him to decide this verdict?
There are almost exactly 200 exhibits, including photographs, lab reports, autopsy reports, it's crime scene diagrams, maps, introduced at trial. The jury deliberated for 35 minutes.
35 minutes. Well, must have been slam dunk then.
You know, I would never describe any case that goes to trial as a slam dunk.
No, you wouldn't.
Now, what's the response been from local law enforcement to I mean, I think we've gone from pretty laid back, maybe take it easy kind of prosecutions, the pace of prosecution, to now we're moving pretty fast. Are you moving to the guys saying, hey, slow down, we can't keep up with you? Or
Not at all. And, law enforcement, we're working hand in hand with them. We got just a fantastic group of law enforcement, great sheriff's offices, great police offices, or police stations. The GBI has been fantastic to work with. All of them, they appreciate the fact that we're taking their work seriously and that we're trying to recognize their effort in the courtroom. And that at no point I've ever heard, hey, slow down. They're thrilled that we're up to the level and the pace that we are. And our job, we know that we are all a part of the same team. We got to be aligned with each other and make sure that we have each other's back. I'm on call 24 hours a day for law enforcement. I've been out to the scenes of murders with them, as they conduct their investigation. I'm not as a witness, not oversight, just to be there, to have familiarity with it, to know the case from the outset. So we're working hard to make sure that we are both working hand in hand and to bring real justice to this community, because there's been law here, there just hasn't been justice, and that was the problem. That was the fault of the DA's office and not the fault of law enforcement.
I would imagine that the cops and all would really be appreciative, because at least you see on television on these shows that these cops are real frustrated because they arrest the bad guys and nothing ever happens. You see that all the time. I guess it's true in real life.
And I think that's the frustration that a lot of law enforcement's had for a long time, is that they see the same people coming back over and over and over again with no real consequences delivered to these folks. That's not the game we're playing. I don't know if a recidivist notice has been filed in the last 10 years in the circuit, but in every case where a person has a prior felony, we're filing recidivist A under 1710-7, which means that the judge will have to impose the maximum sentence for the new offense they've committed. For every case that they have 3 prior felonies, we're filing 1710-7C, which means that whatever sentence they receive in confinement, they're not eligible for parole. So we're using those tools to deliver real justice, to get those guys off the street who are a real menace to society.
And that had not been the case prior.
As far as I could tell.
So what are you getting everything from each county? You cover 5 counties: Oglethorpe, Madison, Hart, Franklin, and Elbert. You getting good support from the purse strings, the guys who decide how to fund your office?
Recognizing that every county in the circuit has budget issues, that they have been as accommodating as I think they possibly can be, and I appreciate the fact that they have been so accommodating, because we recognize the need for to be good stewards of the public's resources and of the people's money. We're trying our best to keep the budgets as tight as we possibly can, but we have to have the funds in order to operate. The state pays the big expenses for the office, which is the salary for the ADAs and for some of the administrative staff, and then the counties pay for the operating expenses of the office, which includes everything else. The things that keep the lights on, copiers, toner, telephones, computers, internet service, and 2 of the counties actually pay for an additional secretary to have with the office. But what we've tried to do in this, we've evaluated the overall budget and then apportioned it based upon population. So each county gives a representative share of the overall circuit.
Well, would I be wrong to assume that if you are sending more guys to prison out of the county jails and you are discouraging people from breaking laws because they might have to go to prison, that's a savings to the county?
And that's the goal. And what we're trying to do is reduce the time that someone spends in jail from the time of arrest to the time of conviction, to reduce those number of days in the county jail, because those are expensive days. We're working with the Department of Corrections to try to get a video teleconference set up so that we can sentence people who are in prison for new and who still have pending offenses from prison, rather than transport them back to the counties, which costs counties money, and have them in the jail in order to bring them to court and sentence them. If we can do it via video teleconference, that would enable us to avoid the expense associated with transporting state inmates.
Who decides whether we can do that or not?
It's going to take some time and working with the State Board of Corrections.
I see. Okay.
You got any good cases coming up?
Can't really talk about cases coming up.
Oh, man.
The rules of professional responsibility prohibit me from making extrajudicial statements that might tend to heighten the public condemnation of the accused. But you know,
What did he say?
He said we're going to jail if we keep talking about it.
no, that's just a rule for me. Sorry about that. I think I hit the microphone there. But we're having such a great time. It's a lot of work. It's we're slogging through long hours, long days, long weekends. But I can't complain about it because this is my passion. This is what I love. I'm glad to be here. I'm grateful to the community for putting me in this position. And I am eager and anxious to continue serving and getting this situation under control, getting this backlog under control. And my goal is to make this circuit the safest in the state.
The backlog, you mentioned earlier, 12% or something like that. Through that, in your first 4 years, you think it'll be 100% finished with the backlog?
Well, the term backlog, we continue to take new cases in. So the goal is to be current. I mean, to be as current as possible. My goal, and I'm hoping we can do this, but ideally, I would like to see us hearing no more than 750 cases total across the circuit at any given time that are open, meaning pre-indictment and indicted cases. We started off with 3,240 plus for 5 assistants. And that's just an overwhelming case number. If we can, but if we push hard and we get past it, what I'm feeling, the sense I get is the more we start to take this down, the rate at which we'll be able to take it down is going to grow. And so within the next few years, my goal is to get to a point where we're about half, and then by the end of my 4 years, I'd like to be at around 750. That's the goal.
Well, I guess I know I have a simplistic way of looking at things, but I guess if the word gets out amongst the criminal element in society that we've got this bad DA that is going to send you to prison for life, or if the word gets out that my guy really got me a great deal of life in prison, that word gets out, I would imagine people will stop either breaking the law or making these plea arrangements.
That's the goal. And we want people to accept, we give great consideration to early acceptance of responsibility. Acceptance of responsibility is the first step towards rehabilitation. So if you're eager, if you really want to be rehabilitated, if you think you deserve a chance on probation, then resolve your case quickly.
Fess up.
That's right.
Fess up early. You want to ask him about this constitutional issue we've been raising about search and seizure and all? He's an expert.
I worry about too many things, but hey, all right. Now, I heard from somebody that, in Georgia, that the most powerful guy almost is the game warden, because game wardens, according to this fella, game wardens can search your cars, search your houses, search anything without a warrant and without, stating the purpose.
Probable cause.
Yeah, that's what they call it. Stating the purpose for which they are searching. And I was saying, I didn't at first. I just thought, and I didn't even listen to it because I know that the Fourth Amendment of the Constitution says what it says. And I was mentioning that to someone else, and they said, well, let me just Google it. And it said Georgia, California, and a couple of other states have these laws that allow them to do that. Now, I started Googling. I couldn't really find anything that said that specifically, but I found a bunch of chat rooms where people were complaining about it and that sort of thing. And I think Wikipedia was not really all that clear, but they did say that Georgia, California, and these other states have some kind of law that I couldn't understand it because I'm not a lawyer, but what do you know about that? Do you think that game wardens can search anything, anytime, any place?
I have never heard that, and even if it were a law in the state of Georgia, it wouldn't pass constitutional muster. The United States Constitution is the first and foremost document in our land, And the rights afforded to us in the United States Constitution cannot be taken away from us by a state. A state can actually give us more rights, but it can't give us less than the Constitution guarantees us. So the Constitution's guarantee against unreasonable searches and seizures and warrants not issuing except upon probable cause is a guarantee of the Fourth Amendment. And a state couldn't bypass that by giving powers to an individual who says the Fourth Amendment doesn't apply to you.
Good. I'm glad to hear you say that because I've been worried to death about it. You know, this fellow that's the head of the NSA, what does that stand for, Lee?
National Security Administration? I don't know. What does it stand for?
I think it's agency.
Agency, okay.
Yeah. Well, anyway, whatever it is. I saw that guy on television, and they were asking him about this Fourth Amendment and how it applied to his outfit. And he said, well, the Constitution says that we can't conduct unreasonable searches. Of course, he left out the rest of it, but they asked him and said, well, what about probable cause? He said, no, that's not in there.
Well, I think, and maybe it might be administration. I'm thinking of Central Intelligence Agency. Anyway, what the NSA is doing is not gathering evidence for a criminal case. They're doing an intelligence gathering. And so because that evidence isn't going to be used in a criminal case, whether or not the Fourth Amendment applies really is a question.
Well, I hope they decide that it is like I hope it is, but...
I hate the thought of Big Brother watching too. I know what you mean.
But I mean, I just thought it was incredible that the head of the NSA, that's a pretty stout job, that the head of the NSA would say that the Constitution doesn't say anything about probable cause, but it just doesn't allow him to conduct unreasonable searches. Well, that was crazy.
And what a lot of people don't know is the NSA is 7 times larger than the CIA. It's a big organization.
Yeah, I didn't know that. I'm saying yeah like I knew that. I didn't know it. Yeah.
Something keeps flying behind your head. I don't know what that is. I guess it's a word. Drone? No.
But you have a drone attack?
No, it's not a drone. All right, Parks, what, the fellow that came up from Augusta is it's like a district attorney and then
Chief assistant.
Mm-hmm.
Jeffrey Fogus.
Now, he's a fireball, right?
Jeffrey Fogus
we think
is a
you've
fireball.
got energy. He's really got energy.
When the grand jury toured the sheriff's office, Sheriff Cleveland said, I don't know if you've seen his assistant yet, Mr. Fogus, but I think he might be on methamphetamine. Either that or he grabbed a live wire out of the wall. That's right. Jeffrey is a bundle of energy, but I mean it's all focused in one direction, and that's justice. Jeffrey works just long hours diligently, making sure that he's ready on his cases, and then we resolve these cases. He's been out with training all the law enforcement agencies in the circuit on updates in case law, and also talking to them about what we would like to see in case files. We don't have the authority to direct law enforcement or direct their investigations. We're working together with them and telling them, based upon our experience in the courtroom, what's really effective in an investigative file, what we need to see in an investigative file, how an investigative file needs to be wholly objective, and the kind of language that we need to use in an investigative file, as well as pictures and why they're important. But Jeffrey is a great friend. We started practicing in Augusta together years ago before I went into the Navy. And then when I came back off active duty and went back to the DA's office there, Jeffrey was in Pakistan at the time, working as a missionary. He took his wife and his 2 boys with him to work as a missionary, and his 3rd son was actually born in Pakistan.
Wow.
And then he spent a year over there until the situation really kind of destabilized, and he had to leave the country. And he went back to the DA's office in Augusta, and I was thrilled that he accepted the position of being my chief assistant district attorney.
Well, it sounds good. It all sounds good. I appreciate your hard work.
Yeah, and we thank you for being here.
Will
you come back? And
I
give
will.
us an update?
Thank you for having me.
We'd like to hear some more about those successful cases. And,
certainly.
Thank you for what you're doing. It's a great change for Hart County. We're a part of that. Parks White, District Attorney for the Northern Circuit. And we'll be right back with the second half hour of Back Talk Live right after this message.